Hi, it's Mike DelSignore. In today's video, I want to talk about a great case result I had in Ayer District Court this week where a client was found not guilty of an OUI offense. Was a case where the officer alleged that our client was driving somewhat erratically, crossing the marked lanes on a few occasions and not staying within the lane. Now, that happens all the time. People don't drive perfectly straight down the lane. Sometimes, you might be distracted, you might be tired. There's nobody on the road. Sometimes we lose our concentration. Doesn't mean someone's under the influence of alcohol. This was an interesting case in that the officer testified to some things that some admissions. The client initially said they had one drink, then they said they had two drinks. So there was sort of inconsistent answers about how much alcohol my client had. And sometimes people get concerned about that. They feel like that means you can't win the case. Certainly hurts the case if there's inconsistencies, but keep in mind, when you look at an OUI case, you're basically looking at the entire case. And from the defense point of view, we're trying to find where we can point out reasonable doubt. So we can point out reasonable doubt in a number of different ways. We don't always use the same tactic. If there's good driving, focus on the driving. If there's good field sobriety test, focus on the field sobriety test. And this was one of those cases where the field sobriety tests were pretty good, that they really weren't inconsistent with somebody under the influence of alcohol. Additionally, when I listened to the officer's testimony and compared it to the report, this is a situation where the officer's report actually was stronger than the in-court testimony. So I was a little more cautious than I normally would be on cross-examining the officer, because I knew that potentially he might be refreshed, or the DA may refresh the officer with the report, and that I could unknowingly bring out harmful evidence in the case. So that's something, having done these cases for years, cross-examination isn't just about asking as many questions. It's not about putting on a show for my client. My clients know that I know what I'm doing, that I've been doing this for years, and that everything has a strategy. I actually leaned over to my client and I told them, I said, I'm probably not going to ask as many questions as I normally did, because I thought that the evidence came in pretty good for us. So you got to be paying attention. You got to listen to what the officer says. And having done this for years, I'm always listening. I get new evidence all the time in court from what the officer says. If the officer says something different from the report, I'll bring it up and I'll impeach the officer with the report. Often you have, it's common to have like additional unsteadies come in. I had a trial a couple weeks ago where there was nothing about the client being unsteady getting out of the car. Then all of a sudden on the stand there was. So you bring the officer back to the report. And many of these officers probably don't do it intentionally. And you generally want to take a soft approach with the officer, which is contrary to, I think, what many people think when they hire an attorney. They think we're going to be very aggressive, confrontational, bullish in court. But the problem with that style is it actually turns everybody off. The judge, if it's a bench trial, the judge isn't going to be happy with it. It's a jury trial. A jury, unless the officer is lying, misleading, unless you sort of permission to attack this officer, the officers come to court with a lot of credibility. So you're taking on a greater burden than you need to if you're trying to get the jury to not only believe your client wasn't impaired, but this officer was a liar. So we want to basically challenge the officer as little as possible to get the result we want. We don't want to take on any greater burden than we do. Because remember, in this case I had in Ayer, in every criminal case, the defendant is presumed innocent. The government's got the burden of proof beyond a reasonable doubt. So I've handled a lot of cases out of Ayer. Ayer courts, the police from Littleton go to Ayer, Groton, state police brings cases to Ayer. So a lot of different towns. I'm familiar with them all. Most of them have some form of video. Sometimes video can be helpful, sometimes it's not. If it's not helpful, I don't use it. But I can always use the information from the booking in cross-examination, even if I don't want the judge or the jury to see the actual video. So remember, if you're charged with OUI and your case is going to be heard in Ayer District Court, I've handled a lot of cases there. Remember, you want to be strategic about how you question the officer. You want to create a theory, a theme, why why there's reasonable doubt why you weren't under the influence. In the case that I'm discussing that just happened, I offered some medical records to show that any unsteadiness could have been caused by a medical condition and not alcohol. So we're always trying to think of alternatives to, well, the officer thought this was alcohol, but why could they be wrong? Medical. The person could be tired, fatigued. This was a case where my client had been working long hours. So we want to put all these alternative theories to show to a judge or jury that it's not clear, it's uncertain, there's doubt here about whether you were under the influence at the time. And if you're charged with OUI and Ayer, I'd be happy to help you. You can call, text me anytime. My name's Mike DelSignore. You can reach me at 781-686-5924. I'm here to help. My passion is to help people charged with OUI, and I've helped many people right out of Ayer District Court. I know the players, the judge, the DAs, everyone pretty well in that court. I've been going there for years, and I'd be happy to help you with your situation.